The U.S. Supreme Court only stated that the era of prohibitions on assault weapons is coming to an end. The justices have finally intervened after years of observing from the sidelines as lower courts flagrantly broke their precedents. This upgrade is more than just a legal one. It is the beginning of a constitutional earthquake that may remove every AR-15 and semi-automatic rifle limitation throughout the country overnight. Should you live in California, Illinois, New York, or any of the 10 states at the time making the most generally used firearm illegal, and you must pay close attention, America. Pay attention. The Supreme Court granted certiorari to Snope v. Brown on November 8th, combining it with issues from Maryland and Illinois that had been sitting in the backlog of petitions for over 18 months. This wasn't simply any choice. The court carefully chose situations that illustrate the most immaculate constitutional issues with the most significant circuit splits. What comes next will reinterpret the Second Amendment, which has been in place for a century. Subscribe right now and push the warning bell since the mainstream. The media mainly ignores the particular legal actions taking on in Washington, D.C. right now. Additionally, these acts constitute the secret to retaining and bearing arms. Right now, we are facing a national crisis of prohibited guns. As we sit here today, more than 100 million Americans, more than one-third of the population, live in constitution-free areas where possessing a typical semi-automatic firearm carries a 10-year sentence in federal jail. We aren't talking about weapons of war or odd military equipment. We're talking about the AR-15 platform. Our rifles are so prevalent that there are more of them in civilian hands than there are Ford F-150s on American roadways. With around 24 million of these weapons in use, they are the best-selling rifles in 41 of the 50 states in the United States. However, more than 200 specific models are specifically prohibited by law in jurisdictions including Maryland, Hawaii, and New Jersey. 45 particular rifle models were prohibited by the Maryland Firearms Safety Act, along with any imitation weapons that share similar operational features. When you account for all the variations, that figure in California is more than 300. After the Highland Park shooting, Illinois passed the Protect Illinois Communities Act, which, among other things, outlawed semi-automatic rifles with detachable magazines. These states have imposed restrictions on more than simply firearms. They have sought to remove an entire type of technology in the possession of law-abiding citizens. How did we get here? For many years, the Supreme Court produced crucial rulings like Hella and Bruin, establishing that the government cannot restrict regularly used firearms for valid grounds. But instead of under the law, inferior circuit courts participated in the actions that Justice Clarence Bruin evasion has been referred to by Thomas. In the 4th, 6th, and even the 9th circuits are virtually eliminated. Rouge, creating tests that aren't in the Constitution to justify retaining these bans in place. After the Supreme Court ruled Heller in 2008, ruling that the Second Amendment defends a person's right to carry weapons, lower courts encountered a difficulty. How do you uphold popular gun control laws? When the Constitution states that won't be violated, they received imaginative. Federal appellate courts established the two-step method that the Supreme Court never approved. The first step asked whether the restricted weapon was protected by the Second Amendment. Step 2 applied intermediate examination, weighing government interests at odds with those of persons' rights. This arrangement made it feasible for courts to respect the rights of the Second Amendment exist while maintaining practically any limitation that they individually desired. What they called the military features test was invented by the Fourth Circuit. If a firearm has qualities in common with military armament, courts can exclude it from constitutional safeguards based on its design as opposed to its customary employment. Some even went so far as to claim in the most recent Snoke v. Brown case that AR-15s are military-style weapons designed for extended combat, completely ignoring the fact that they are used for hunting, sport shooting, and most importantly, home protection, millions of times annually. Additionally, the ruling in Friedman v. State allows states to prohibit AR-15s even if they are widely owned, since they are more deadly than other guns. Review that logic, with caution. The more popular a firearm develops, the more harmful judges proclaim it, which somehow justify forbidding it despite its broad use. It's constitutional reasoning that devour itself. Courts use statutes from the 19th century to justify the ban on Bowie knives and modern firearms, even though such rules only governed the carrying of firearms in public, not the ownership of entire classes of weapons. The Ninth Circuit even maintained California's restriction by invoking ancient English regulations prohibiting crossbows among the peasantry. The 14th century law disarming English commoners provided the pretext for disarming Americans in the 21st century. This was the breaking point. The Supreme Court observed this judicial uprising for 3 years and seen the foolishness reach a level that the highest court in the land could no longer ignore. The Supreme Court then dismantled the entire system after the Bruen case in 2022. According to Justice Thomas, if the Second Amendment's plain language addresses the behavior in question, the Constitution presumptively protects it, and the government must show that its limitation is consistent with the country's long history of gun control. Interest balancing is no longer necessary. No more text, history, tradition, and intermediary scrutiny alone. Lower. The courts should have ruled that assault was unlawful. Bans on firearms immediately. However, this is what they did instead, which compelled the Supreme Court to act. After Bruen came down, gun rights activists expected lower courts to rule legislation unlawful fulfill the requirements of the historical tradition test. Instead, federal courts participated in what can only be called as constitutional opposition. After rehearing the case after Bruen, the Fourth Circuit ruled that the Supreme Court's methodology was impractical and should not be applied to assault weapon prohibitions. According to a federal judge, the Supreme Court's precedent is unsettling. As a result, he is not focusing on it. Despite acknowledging that AR-15s, of which there are 24 million in circulation, met Heller's common usage threshold, the courts in the District of Illinois decided that they might be outlawed anyway due to the potential for misuse. The rationale is quickly investigated. Prohibiting cars, which kill 40,000 Americans annually, or alcohol, which causes 95,000 deaths annually, would be justified by the potential for abuse. Due to Bruen's support for assault weapons, 23 federal judges have now rendered rulings that directly violate the Supreme Court's order. That's not a few renegade judges misinterpreting the precedent. It's systematic disobedience of constitutional authority. 9 circuits have so far spoken on the ban on assault weapons, with 3 striking them down and 6 upholding them. The Supreme Court's intervention was inevitable due to the circuit split. But timing counts, and the court's choice to give certification now instead of waiting for another term to reveal anything crucial. The majority of conservatives isn't only annoyed with the lower court defiance no longer, they're poised to reaffirm constitutional power with a ruling that will be binding on all states and nationwide federal court. Not a single case was chosen by the highest court, randomly. Justice Brett Kavanaugh, who was joined by the conservative majority on the court, has essentially laid out the plan. They are awaiting the ideal vehicle, a case that goes straight to the heart of the entire assault weapons story rather than just challenging a little section of a law. The court is no longer merely searching for a basis for avoiding the altercation, they're hunting for the best timing to give a clean finding, one that doesn't merely strike down one legislation in one state, but establishes a national precedent that forbids any state from ever prohibiting a semi-automatic weapon based on its cosmetic features again. However, what would the day following such a decision look like? And more crucially, what does the evidence actually reveal regarding these guns that may demolish the government's entire case? Despite the media's rants about war weaponry, the actual data that the Supreme Court is currently reviewing paints a quite different picture. The entire defense of assault weapons bans are based on a clear statement. Banning these rifles will save lives because they are extremely dangerous weapons of war that have caused mass casualties. That claim is not supported. Interaction with real data. The FBI's standard crime reporting data for 2022 reveals that weapons of all kinds, such as hunting rifles, AR-15s, and every other rifle category combined, were employed in 456 killings. That year, 8,029 murders involved handguns. Compared to rifle killings, there are 17 times as many homicides involving handguns. Knives were deployed to murder 1,630 people, more than 3 times the number of the rifle total. Hammers and other blunt items killed 521 people. Human hands, 749 individuals were murdered by feet, 64% more than all guns combined. If assault, the most risky item is armament. Why do they only cause a small percentage of murders compared to weapons that no one owns, which calls for a ban? And is there a threat that warrants their prohibition? The FBI's active statistics on shooters from 2000 to 2023 show that handguns were used in 62% many incidences, but any form of firearm showed up in just 31% of cases. States that assault weapon restrictions don't imply reduced homicide rates in compared to those in states without them. California has continued to extensive regulation since 1989 and observed a rise in mass shootings casualty rates from 2019 to 2023 than Texas, which has no such constraints. There is no connection between public safety and the ban on assault weapons. The idea that these guns are the principal generators of violence is an empirical fallacy. According to the Supreme Court's Bruen decision, laws must be consistent with tradition and history rather than theater and fear. The government's compelling interest case starts to fade when the justices look at these numbers. The knowledge renders the problem insoluble for states that support assault weapon prohibitions. They must convince the Supreme Court that weapons that are used tens of thousands of times annually for defensive purposes are too dangerous for citizens to own, and they must explain why pistols, which are responsible for 8,029 fatalities annually, are still legal, while rifles, which kill 456 people annually, are prohibited. But there is something involved in the current court battle that could permanently resolve this disagreement. In Insnope versus Brown, the petitioner's brief provides an argument that extends much beyond if many people own AR-15s. The Supreme Court is being asked to rule that firearms appropriate for the strongest use of militia's constitutional safeguards, not the weakest. This affects the fundamental basis the lower courts adopt to support restrictions. In the past, anti-gun activists have argued that a weapon is too military for civilian use if it features a collapsible stock, a threaded barrel, or a pistol grip. However, new filings indicate that legal experts are citing the United States versus Miller case from the Supreme Court in 1939. In reality, the court held in Miller that a weapon needs to be safeguarded in order to have some plausible link to the preservation or effectiveness of a well-regulated militia. In other words, rather than being at its weakest, the Second Amendment's protection is greatest for weapons that have military value. The short records that private individuals at the founding possessed weapons of military quality as a matter of course. The Pennsylvania long rifle was the most advanced military weapon of the time, and individuals owned them freely. Individual. The identical muskets that were used by soldiers from the Continental Army. Both artillery pieces and cannons were privately owned. The Militia Acts of 1792 mandated that physically fit men possess both ammunition and military weapons. Congress did more than merely let people to own military hardware and weapons. They mandated it. States like Illinois and Maryland have reportedly unwittingly stepped into a constitutional quagmire by designating the AR-15 as a war weapon. Should they accept that the AR-15 is a weapon fit for a military weapon, they are essentially admitting that it is precisely the type of weapon that the Second Amendment was designed to protect. Should they claim that it isn't a weapon for fighting, their complete risky and distinctive the case against it is disproved. It's a checkmate situation that the Supreme Court is evidently eager to address. State attorneys in general are put in a challenging position by this argument. If they recognize that AR-15s aren't genuinely military firearms, they no longer qualify as dangerous enough to be prohibited. Should they recognize that AR-15s are military appropriate, in that case, they are precisely what the Second Amendment protects. By claiming that AR-15s are military style but inappropriate for the military, the reply briefs try to sidestep this trap without making a contradiction. By definition, a product is in common use when 82% of the country views it as a typical legal tool. By outlawing them, the other 9 states are not controlling weapons. They're acting as outliers that are defying the national norm. In a recent comment, Justice Kavanaugh said that it is analytically challenging to distinguish between a semi-automatic rifle and the semi-automatic handguns that the court has already safeguarded in Heller. The nuclear option is currently buried, lawsuit that is not seen by most people. States that oppose guns have long held that although a weapon could be covered, the magazine is just an attachment that can be limited to no more than 10 rounds. The island is at the peak of its fever in 2026, as evidenced by cases like California and Rhode Island's challenges in Duncan vs. The Supreme Court is currently debating an argument that will end this dispute once and for all. It is useless if it has no arm. Its feeding mechanism. If the court concludes that weapons are protected by the Second Amendment with their regular factory-issued arrangement, then any magazine ban from Washington to New Jersey in the United States overnight it goes. The domino effect is this: if the AR-15 is protected, then it was the normal 30-round magazine, intended for utilization, is preserved. If the Glock 17 is protected, then the 17-rounded comes with a shielded magazine. This would effectively restore the 100 million Americans' rights to possess contemporary self-defense gear without fear of being charged with a criminal for a piece of plastic and a spring. If the Supreme Court strikes down assault weapon bans as being against the Constitution, the urgent legal, there will be massive implications. It renders all state prohibitions unenforceable overnight. New York, California, and New Jersey, Maryland, Illinois, Connecticut, Delaware, Hawaii, Massachusetts, and Washington is unable to uphold legislation that the Supreme Court considers unconstitutional. The laws become legal nullities. Millions of Americans who reside in places that have banned semi-automatic guns are regaining their constitutionally protected right to buy and own them after decades of prohibition. Gun stores in these states will immediately begin carrying AR-15s and other formerly outlawed weapons. The economic impact will be assessed in billions. When producers move goods to recently established marketplaces that have more than 100 million potential customers, what about those who are incarcerated or facing charges for possessing a forbidden firearm? A ruling of the Supreme Court on this scale causes a tremendous legal tsunami of prospective pardons and appeals, as you cannot be detained for a crime that is not a crime, according to the Constitution. This is not only a win for gun owners, it is a restoration of the constitutional administration. Don't be deceived. The states that are against weapons are already preparing their post-decision strategy, as demonstrated by the state's declaration that every square inch of their land was a sensitive area in response to Bruin. We expect states will attempt to impose high levies, liability insurance requirements, or challenging to pass training requirements. But the 2026 Supreme Court is different. The Bruin evasion has been observed by them. Approaches and the future order is expected to contain anti-avoidance, straightforward enough language that even the most lower court activist judge won't be able to construe their way around it. Oral April is when the arguments are planned. At that time, we'll notice how the justices are processing these inquiries. Listen for how they handle the military argument about weaponry. Check to see if they accept the widely used standard as dispositive. The government's brief is due in February when the decision drops, possibly around late June. The landscape surrounding gun rights in legal America will shift overnight. We are standing on the edge of the biggest increase of Americans' rights under the Second Amendment history. The legal life of the phrase ban on assault weapons, which was coined by politicians rather than technologists, is almost over. You should pay care because of this. Subscribe quickly in order to be ahead of the curve. I'll be discussing the oral arguments as they happen and offering a comprehensive dive into the final verdict as soon as it is issued. There is talk regarding your rights in Washington at the moment. Avoid becoming the last to learn out the verdict.